How's it going? Welcome back to my channel. As you can see, I'm outside today, and I wanted to talk to you a little bit about intellectual property. Mainly, what is Dungeons & Dragons intellectual property? What is it? Why is it? Now, disclaimer, I'm not a lawyer, so anything I tell you is for entertainment purposes only. If you are thinking of creating your own game, especially a tabletop role-playing game, I highly advise you to seek an attorney if you don't already have one. So when you look at Dungeons & Dragons, what do you think? Do you think fantasy, medieval? Do you think monsters, combat, dungeons, dragons? There's a lot that comes to mind. I know there's a lot that comes to my mind. When I started playing as a young kid, I thought Dungeons & Dragons was based on the fantastic illustrations that I saw in the books or on the covers. One of the most iconic covers for me is the Earl Otis painting on the original first edition Advanced Dungeons & Dragons Deities and Demigods. That is burned into my mind. So that, to me, Dungeons & Dragons is really around the iconography and the feel of the illustrations. There's so many illustrators from the original edition, first edition, and in my mind is the original edition, even though it's just a more complex version of the OSR and, basic Dungeons and Dragons from the Holmes box set. But anyway, I digress. So as I was saying earlier about intellectual property, the separation of Dungeons and Dragons game mechanics from the trade dressing, so to speak, is an interesting one, because it's actually very easy to separate the trade dressing from the mechanics. In fact, you could introduce an owlbear or a mind flayer or a five-headed dragon named Tiamat fighting Venger and Demogorgon in Rollmaster, or using Traveler rules, or even Shadow Dark rules, for all that matters. So the point I'm trying to make here is that because there are different laws protecting the rights of companies and individuals, there has to be a separation as to what is copyrightable, what is trademarkable, and what is considered intellectual property. So as an example, Dave Arneson and Gary Gygax and the team at TSR drew heavily upon myths and folklore, legends, fantasy novels, science fiction novels, pulp magazines, etc. So when you look at a monster like Orcus or Demogorgon, you might think, well, I can't use that in my own setting because that's owned by Wizards of the Coast and Hasbro. And the answer is not necessarily, and I'm going to explain this. Orcus is actually the Roman name for Hades, the god of the underworld. Tiamat comes from Babylonian mythology. Demogorgon is mentioned by John Milton in his poems, Paradise Lost. So what's really protected from a Wizards of the Coast perspective is how they form their characters or their creatures or their monsters from these older myths and stories. So as an example, you couldn't necessarily create a devil or a demon in your game world, call it Orcus, and make it look exactly like the Orcus from Dungeons & Dragons. That would be theft. That is not a good use of your imagination as well. However, you could create a character who looks something like Darth Vader and call him Orcus. Maybe he uses a sun sword of sorts and a dark helmet. That would work. Again, it's not very original, but nothing is original. There's no such thing as originality. Originality is just a amalgamation and a mess of other things. Again, I'm not a lawyer, but there are three basic types of copyrights. that you need to worry about if you are a game maker or a writer for games. Number one is there's trademark law. So trademark law protects symbols and logos, word marks, essentially. So the term Dungeons and Dragons is a registered trademark of Wizards of the Coast, who is owned by Hasbro. You cannot use the word Dungeons and Dragons unless you get a specific written letter by Wizards of the Coast saying you can use it in such a way. Now, there is such thing as fair use. However, again, you're going to be treading into some dark waters there. So again, get a lawyer if you're not sure. Patents are another form of protection, and patents are a lot more complicated. Patents protect things that are processes. So as an example, or processes or specific functions. So as an example, the escalator. The escalator was created by someone, I don't know who, and the escalator at some point became patented. So if someone wanted to make an escalator, they could, but they would have to secure the rights of the patent owner and possibly pay a fee. The third and last, of course, is copyright, and copyright is based on works, written works, works of art. So you take a photograph, you could copyright it as your photograph. You write a novel, you copyright it under your name as your novel, as your words. Now, the words themselves are in a specific order, but everybody uses words every day. So it's the originality of your work, your story, is really based on the words that you use, the order that you use them, and how you express the vision of the novel in someone's mind. So those are the three basics. You've got trademark, service mark law, patent law, and copyright law. They're all very different. Look into them and understand them. Now, the thing that is confusing is the difference between what can be patented and what can be copywritten. So as an example, let's take a monster from the Monster Manual. Let's go way back to the first edition, Advanced Dungeons & Dragons Monster Manual. If you were to take the stats for, let's say, an orc and gave it a different name, gave it a different picture, so let's say you drew your own picture of what you thought an orc looked like, and you called it a smork or a dork or a fork, whatever you want to call it, unless you actually specifically verbatim copy the descriptive text of the orc, you're not breaking any copyright laws. In fact, you could probably use the word orc and be okay, as long as you do not copy and plagiarize what was written in that book. You'd have to write your own description of the orc. You'd have to write your own analysis of how they act, what they look like, etc. So when I was going to do a video on the separation of intellectual property of Wizards of the Coast versus game mechanics, this is sort of what I was talking about. And what I mentioned earlier about trade dress, so the trade dress of Wizards of the Coast IP is really around the illustrations, the photography, the language they use to describe their worlds, the world names such as Forgotten Realms, Greyhawk. The thing that Wizards of the Coast would probably come after you for is if you tried to name your game something D&D, meaning like Dragons and Dungeons. Don't do that. Demons and dinosaurs. You could probably do that, but that would be a weird game, and the abbreviation would be the same, so you'd be stepping on some toes there. So again, don't do that. Now, the terms like wizards and warriors, tunnels and trolls, those all work, and they're using the same sort of alliteration that Dungeons and Dragons has. So you can do something like that. In fact, when I was younger, I created something called the Beast Book, which was just my version of the Monster Manual. So you can use your imagination to come up with something unique and technically original, using your own personality. Now, in some ways, Wizards of the Coast has made it very easy with the OGL to quickly determine what is their intellectual property and what is in what you call open source, meaning usable by the public. there's nothing stopping you. In fact, look at Pathfinder. Pathfinder used the OGL back in the early 2000s to create Pathfinder based on the Dungeons & Dragons 3.0 rules. And it's actually a really good system. I think Paizo went a little too far and made it a little bit too complex, but 3.0 was a better version of Dungeons & Dragons than, I'd say, 2nd edition, only because it was very different and it made more sense. It was the first time that armor class made sense. Not having a negative armor class be better than a positive armor class. The rolling system, the D20 rolling system in the original Dungeons & Dragons is very different than it is today in the D20 system. If you were newer to gaming and you started with either 5e, 4e, or 3.0 or 3.5, or even Pathfinder, go back and read some of the look at the tables and read the book, the original Dungeon Master's Guide. The original 1st edition Advanced Dungeons & Dragons Dungeon Master screen is pretty unique because it has a lot of tables in it that you basically need to figure out if somebody hits a certain armor class at a certain level. I mean, there were different matrices for the different classes, like clerics and druids had their own table, magic users and illusionists had their own table, fighters, of course, had their own table. It was pretty crazy. So I've been reading through the new 2024 Player's Handbook, and in Chapter 1, Playing the Game, on page 17, this is a good example. This social interaction example is a good example of what I was talking about with regards to separating mechanics from intellectual property. And this social interaction example involves Dungeon Master and 4 adventurers, Shreve, Mirabella, Aro, and Gareth. And this takes place in Barovia, which is part of Ravenloft. And I quickly read through this, and it's basically the characters meeting the Burgomaster's son, and he notices that the seal on the letter that his father, the Burgomaster, gave to them is not the Burgomaster's seal, and it belongs to what he calls the Devil Strahd, which is Strahd von Zarovich, who is the antagonist in Ravenloft. This example here talks specifically about Strahd. Strahd is a name owned by Wizards of the Coast. You would not be able to use that name without specific rights from the owner. However, it does mention making an ability check. So there's a wisdom check, insight check that is made. There's an influencing action here that happens. So any of the mechanics that happens in a game is really part of the game mechanics is outside of the intellectual property of Wizards of the Coast. So any game mechanics that you're playing with for Dungeons & Dragons is more than likely something that you can use in your own games if you're creating your own campaign world or your own game setting. However, the intellectual property are the very specific parts of the scenario, in this case, Strahd von Zarovich, and the names Irina Kolyana. So I'm going to switch gears a little bit, and I want to talk specifically about 5e conditions. Now, these conditions haven't changed much, although the one condition I want to call out, exhaustion, does not meet the standards of the other conditions. It's the one condition that has an exception for some reason, and I don't understand why Wizards of the Coast would do this. So if you look at all of the other conditions, blinded, charmed, deafened, etc., they're all in the past tense because they have binary states. You're either blinded or you're not. You're charmed or you're not, you're invisible or you're not. However, exhaustion has 6 levels. I'm not sure why they didn't do not exhausted and exhausted, and then have exhausted be a little bit more easy to play. I'll get into this a little bit more as to why I'm going to change the exhaustion rules and why I'm going to change the poisoned rules as well. So that's coming up in a future video.